which is why, as frustrating as it may be, as eye-rolly as some of these letters may be, this is why we need to get that criminal case to trial. We don't need these delays. We don't need lawyers that aren't going to help her. If you sign up to get appointed, you get appointed, do your job. Let's get this case to trial. Let's get some finality and resolution. But if she wins, it would be pretty sad at how this system has gone for her as she's sitting presumed innocent in jail, accused of a crime but not convicted. What's up, everybody? Welcome back in. We've got another Sarah Boone letter, but this one's a little different than the last few. It brings in some of her family law issues, which we'll touch on, but we're probably not going to focus on. It's not my expertise and specialty, but it is very interesting, and I'm sure you guys are going to find it somewhat entertaining and somewhat sad as we read through it. In case you can't tell, my voice is a little weak. I had a Halloween party last night. I didn't feel like I screamed that much, but I must have. And then very early this morning, an intense pickleball match, which is probably what finished it off. But we are going to push through. No clips today, just reading, but we'll make it happen. So I apologize if it's a little low. We will push through. We will make it happen. And Lori McGee, my good friend over in Orlando, sent me this letter and an order that we're going to read that happened after this letter from the judge she addressed in this letter. So stick around to hear what the judge had to say because it's very interesting. So thank you, Lori. And I'm excited to one day meet you if this case ever finds its way to trial. So hit that like button now if you're continuing to follow this Sarah Boone case. And let's get to this letter that was written back on September 5th, 2023 to Judge Michael Dean. And it is her motion to read letter from respondent and schedule case management hearing. And we're going to hear from Judge Dean what he thinks about the way and form that Sarah Boone drafts her motions. Usually judges take it easy on pro se litigants, but this judge throws a little subtle shot in his order, which we'll read later. In all my attempts, 16 plus, to protect myself and help from the still ongoing hate, lies, slander, degradation, cruelty, and active abuse from my former husband, Brian C. Boone, nothing has been improved, made better, corrected, relieved in any way for myself, the respondent, from former husband, the court, or judge. I have tried everything. I have made innumerable requests and sent many letters asking for aid from all with no success or assistance, listening or care by anyone other than myself, she cares, trying to relieve or altogether stop his inappropriateness, bitterness, anger, and wrongdoing. Please see list below of my letters sent to you and court per the Records Management Division of the Clerk of Courts when for the third time I tried getting a copy of an active dissolution of marriage agreement. I cannot have because they are wanting payment in order to receive and I am in jail. I also have no bank account after the one I had was closed after having for 30 years due to non-payment of alimony from former husband and stated in prior letters. So here are all these 16 plus prior letters that she wrote. It is appalling how uninterested, uncaring, and nonchalant you and the justice system are about my side in any of this, and will not listen without the right paperwork and attorney, knowing I am actively being taken advantage of and wrongfully mistreated by former husband Brian C. Boone. So it's kind of like the boy who cries wolf. When you keep saying everybody's against you, the justice system's so unfair, nobody's helping you, at some point you got to look at yourself and see if you're part of the problem throughout this process. You have continuously enabled him and given him a self-appointed right and understanding to keep doing, saying, and taking everything wrongfully and illegally from me, including and especially the love and respect from my son. It is not okay. So at this point, she's complaining, before we get to the quotes, that her husband has stopped paying her alimony. Now, I don't know if that's true or not, but some people may wonder, if you're in prison, do you still have to keep paying the other person alimony if they're in prison? The answer is yes, unless you get a court order to change or eliminate your alimony. And in some cases, you can hold payment, put it into the court's registry or some kind of account, like escrow account, to hold it until the court makes a decision. Then if they say you have to pay them, you can back pay them. Or if the court says you don't have to pay them, then you might not have to pay them. And we're going to get a little insight into which way this court is leaning based on Sarah Boone's current circumstances. Now, additionally, she complains about how her husband is acting with her son and, putting certain thoughts and words in her son's head. So let's listen to some of that. You're a killer. That's why I'm not doing anything. Former husband in front of son on phone. You're not important to anyone. Former husband. You are not a priority. Former husband. Dad says you're annoying and beg all the time. Son. Told me after asking him to ask former husband if he finally ordered a book and not in hot meal after being made to call daily to check for 13 weeks. I lie to you because I can. Dad does it all the time. You make no difference in our lives, former husband. So again, these quotes, while they are very sad, and nobody would ever want this to happen to family members or to a son in their own situation, it's not unusual for this type of stuff to happen in family law cases. And the court does not step in and tell one spouse or the other to be nice or to not voice their opinion. They may say, this could affect the case for the well-being of the son, give some advice, but that's not the court's job in a family law case generally. That's okay with you and acceptable, Judge Dean? Is that what you are giving him permission for and to keep doing in front of my son? Again, it's a he said, she said. In family law cases, they get dirty, they get ugly, both sides constantly accusing each other of things. The judge does not step in and handle all of these little disputes. Why won't you stop any of his abuse, verbal, mental, and emotional? Why aren't you, as my judge, doing anything to hear or understand both sides? Again, it's not really the time for it while the case is being litigated in family court. What else needs to be done by my former husband in order for you to help me? What else can I do? I have not done already for any relief on my side. Stop enabling. Judicially, you must know this is wrong and how I am being treated. She's using words, but not correctly and not asking for the right remedy because that's not what the judge is going to do in this case. I am told every time when trying to reduce any anguish or mistreatment from former husband and cooperate, trying to help. The judge doesn't care what you write. That's from her former husband. My son now says, her son, the same when I correct him on how he was being mean and rude to me. He's never going to do anything for you until your trial is over. And even then, it will still all be in my favor. My other document is ready to go, so I can take the rest. I have an attorney. You deserve nothing. You mean nothing. This is her husband stating his legal position. And when he says until your trial is over, he's referencing her criminal trial. So we'll see if the judge agrees with him or not when we hear the judge's order. Then former husband gets his precious attorney to file another answer denying allegations because I'm telling the truth all the time about his awful lies and I am right. Judge Dean, so I have to continue taking former husband's abuse, neglect, unlawful actions, cruel comments, and hate until my trial, if and when it happens. That's true. And just another reason why it's frustrating with the delays, that some of which may be outside of her control. However long that will be, now considering my attorney has withdrawn from my case and no date of trial is known or will be known for an undetermined amount of time. That does suck. But when she mixes one legitimate complaint with 100 annoying complaints, there's some frustration and inability to really help her by the judicial system. How much more hate and disrespect will former husband encourage my son to keep lying and overall being mean to me, his mother? Former husband is teaching and reflecting a terrible example of how women can and should be treated. Nonetheless, the mother of his child. Now, I have to step in and say the hard truth here, that her husband is able to have this effect on her son because she is not able to take care of her son. She's not able to even split custody because of her being in jail, decisions that she's made, statements she's made to law enforcement, things that have happened in her life, by her own words, things that she's admitted, whether or not she's guilty of the crime charged, have given enough for probable cause for her to be sitting in prison. So a lot of this is from her own decision-making, legally speaking, and she's blaming other people, but you're going to see in some of the dissolution documents and orders that when you can't even share 50-50 custody, you lose some of the benefit of the doubt. This is egregious and wrong. Please read my prior motion for case management hearing I sent on 6/28/23 with no response. I am requesting again, please, to schedule. It is fair, and there are too many topics to be discussed, including my attorney, to write. And I only have one pen. Necessary, lawful, active, important topics. What is the certified notice of delinquent support filed on 8/3/23? Again, I don't know. I haven't looked at all the family law documents, and I wouldn't be able to answer some of those questions anyways. Please grant my motion and schedule my imperative, overdue, and owed meeting. Everyone needs and must have the same understanding now and in the future. It is fair. What else can I do? What's left except for begging, which former husband says I do all the time? What am I doing wrong in order to be treated rightfully, properly, ethically correct in order to finally receive your judicial assistance? How I am and have been and will be treated by former husband Brian C. Boone is unfair, malicious, and wrong, and should not be in any way allowed to continue. Stop. Please see, please listen, please help. Judge Dean, what was the reason for your comment made in your courtroom about former husband violating my constitutional rights? I don't know what they're talking about there. Maybe it's her right to remain silent. Maybe it's her right to a fair trial on the criminal side, the constitutional rights that are protected that she has until her case is gone, because it seems like Brian C. Boone thinks she did it, calling her a killer, convicting her basically, which can let us know he's probably going to be a witness for the prosecution in the criminal case. But the judge in this case is probably saying she's presumed innocent. Let's wait to see what happens in the criminal case first. If you're not going to help or uphold said rights and lawfully allow me to use, what's the point? Why do I even have? I do in order for you to remark and see they are being violated. Please schedule. It is my right. It is fair. Please send a copy of this letter so I know it was received and will serve as my receipt. Sarah Boone. Attached. And she says her dissolution of marriage agreement is still active till 2025, which could mean she is entitled to alimony. I'm not saying she's not. But from the Legal Aid Society, they said, Ms. Boone, we received your letter requesting legal assistance. This letter is to inform you that the Legal Aid Society of the Orange County Bar Association will not be able to assist you regarding family law matters. Our office receives hundreds of requests each month for free legal assistance. While we would like to help as many applicants as possible, due to limited staff and other resources, we're unable to assist everyone who's contacting us. So where do you think sitting in jail waiting a murder trial fits in people that the Legal Aid Society wants to help and use their resources to fund? As a result, we have established case acceptance priorities to address the most pressing needs of our client community, and thus, we do not accept matters that involve alimony or custody time sharing on behalf of a parent who does not have the child residing with them for at least 50% of the time. And why doesn't Sarah Boone have the child at least 50% of the time? Because she's sitting in jail. Now, if she ends up winning her criminal case in criminal trial, she can look back and point that this was the reason for a lot of her issues in her life, including the family law matters. But if she loses, it's kind of why we're here. Our consideration of your case was limited, and she underlines this part. Our decision not to provide legal assistance to you does not mean that you do not have a case, a good case, or defense. You should be aware that the passage of time might prevent you from pursuing your claim or defense. We are not aware of any free legal resources to assist you. We suggest you contact a private attorney of your choice or the Attorney Referral Service. The Attorney Referral Service is a service available through the Orange County Bar Association, and their phone number is this. The Attorney Referral Service provides the referral free of charge to any attorney who practices in your area of law. If you would like to obtain the services of an attorney to talk to, the attorney will charge you an hourly rate for his or her services to represent you in your case. Now, she underlines this language like as if it says she has a good case, but in reality, this is a form paragraph that they add as a CYA to every letter that they reject. Lots of lawyers do this. We have some form language we put in our rejection letters as well. So it doesn't actually mean she has a good case, which is kind of, I think, what she thinks it means. All right. Let's now take a look at Judge Dean's order in this case. We'll zoom in a little for you. And this was on October 16th. So it's after, filed 17th, but he signed it the 16th, after her letter. Ordering following case management conference, this cause, and again, this is from the family law case, Brian Boone petitioner, Sarah Boone respondent. Case management conference on October 16th, so she got her wish. Here's the order. Both parties appeared, including a motion to withdraw by respondent's counsel, Frank Bankowitz. No objection to withdraw. Bankowitz is hereby removed as counsel for the respondent. Counsel shall provide more formal proposed order in this removal within 10 days. Case management conference discussed the status of the case. Now, what's weird is Bankowitz is appointed as her criminal counsel. So I don't know what work he was doing on this case. Kind of strange. I don't know if he was submitting his hours and getting paid to also work for this case, or if it was just an addition for her to say she has no lawyer anywhere, so we need to continue this. I'm not really sure how the family law court handles when criminal counsel is appointed in the criminal case based on the client's constitutional rights there, because you don't have a constitutional right for a family law lawyer to be appointed for you. So I don't know the answer there. So what happened at the case management conference? They talked about petitioner's request for a reduction or elimination of alimony and for relocation. So Brian Boone's the petitioner. He asked the court to reduce or eliminate the alimony. Sarah Boone's life doesn't quite cost what it used to, / maybe we should eliminate it based on the circumstances we're dealing with, Judge. Respondent is currently incarcerated in Orange County Jail pending a trial on a charge of second-degree murder. We know about that case. The court cannot hear respondent's motion for contempt, that's Sarah Boone's motion for contempt, regarding unpaid alimony until after a final hearing is held on the respondent's petition for reduction or elimination of alimony. So basically, they're saying we can't hold Brian Boone in contempt for not paying the alimony until we hear his motion to see if that alimony should be eliminated in the first place. So first they're going to hear, should the alimony be reduced or eliminated? And then if the answer to that is no, it shouldn't be eliminated, then maybe Sarah Boone will win her contempt hearing. But if he does win and the judge does eliminate the need for alimony or reduce it greatly because of her new circumstances that weren't in place when they made their agreement, then maybe it's null and void. The respondent expressed frustration, that's Sarah Boone, at not having matters heard and not being adequately informed about her case. The court explained that the family case is on hold pending the outcome of the respondent's criminal case. Exactly what Sarah Boone's son heard or said, or what her ex-husband said, a lot of this is on hold until we find out what happens in the criminal case. That's from the judge's own words here. The court finds that permanent decisions regarding relocation and alimony should be postponed until the adjudication of the respondent's criminal case so that circumstances are clearer. What's the long-term view here? What's going to happen to Sarah Boone? Now, it's interesting. I don't know. What do they do with the alimony in this time period? I kind of feel like the judge should make some kind of call, at least in the interim, where Sarah Boone is sitting in jail. At least maybe this alimony should go into the court's registry or some kind of escrow account, like I said. But I don't know. The respondent was informed that she may opt for a final hearing on the petitioner's petition for alimony reduction elimination and her own contempt motion, but that the court would have to consider her current status of incarceration when making determinations. That's a little wink, wink, or tip of the cap as to what the court would do. If you're sitting in prison, I'm going to take you as you are, and it's probably not going to go well for you on the decision to reduce or eliminate alimony. Or you could wait, and if you win, it's probably going to go better for you. Basically, that's what the court is telling Sarah Boone. You should probably wait. The respondent was advised to ensure that any motions filed conform with the Florida Family Rules of Procedure and the Florida Rules of General Practice and Judicial Administration. This includes using proper captions, titles, and certificates of service. That's a little subtle shot to Sarah Boone at the end to say, if you're going to file motions for case management orders, you've got to use proper captions, titles, and certificates of service. Make sure each side gets it. You have the ability to do that even in jail, so make sure you do it right. Some judges pull that punch when it's a pro se litigant. Or maybe say it in open court, but don't put it in their motion. And again, this was on October 16th. It's not going well for Sarah Boone. Are you surprised she's asking for this alimony money? What's she going to do with it? Pay her private investigator, maybe? Use it at her commissary? I don't know. But it's interesting to think maybe she's entitled to at least some of it. And all of this are the results and negative effects of the criminal case. There's no doubt about that. Which is why, as frustrating as it may be, as eye-rolly as some of these letters may be, this is why we need to get that criminal case to trial. We don't need these delays. We don't need lawyers that aren't going to help her. If you sign up to get appointed, you get appointed, do your job. Let's get this case to trial. Let's get some finality and resolution. Because then if she's sitting in prison for 20 years or the rest of her life, we know what's going to happen without this alimony, and it's a moot point. But if she wins, it would be pretty sad at how this system has gone for her as she's sitting presumed innocent in jail, accused of a crime but not convicted. Let me know what you think. Tell me what you think about these letters, and if you want me to keep following this case and reading the letters as they come out in the comment section and by liking the video. You guys are the best. My voice made it through just barely. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media, Twitter, Facebook, TikTok, at Lawyer You Know. But on Instagram, we are still at Tragos Law. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us lawyeryouknow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.